Welcome to our lovely, spectacular, that's a great call. This is Love Makes a Family, and I just want to remind everybody taking this course that MCLE credit to cite in order to get that. So please make sure that you've done so. And I want to thank everyone for coming to our 25th annual MCLE Spectacular. I'm supposed to encourage you to complete and return your evaluation forms, as we would appreciate constructive feedback. So we're going to go down the line, just introducing ourselves briefly, and then we will roll into the first part of our presentation, which is the Love Makes Family part, and then we will then go into talking about transgender issues.
Good morning, my name is Jonna Thomas. I am a Vice President and Fiduciary Advisory Specialist for the East Bay region with Wells Fargo Private Bank. As a lot of you know, I recently transitioned. I have been a litigator for Hartog Berry Hand for about 8 years before that transition. And well, I prepared this presentation, Love Makes a Family, while working with Hartog Berry Hand, and wanted to just thank them for all of the support in this project. And also thank Wells for welcoming me to continue this work once I transitioned over. You need to share that I'm in a non-attorney role, so I am not giving legal advice today, but we're obviously talking about a legal education topic, and so my colleague Summer Selleck is also here to participate in the legal advice and education portion of our presentation today.
And I'm Summer Selleck. I work at SC Selleck Law, and I am an estate and probate litigation attorney in New Walnut Creek. And I am very excited to be here. I know most of the people in the room, and I'm gonna stop there.
Hi, my name is Jess Laird. I am an associate clinical social worker at the Rainbow Community Center, so I'm definitely not here to give legal advice. I am a clinician at the Rainbow Community Center, which is the LGBTQ resource center in Contra Costa County, which is in Concord. I'm also the intake and referral coordinator there, so if you ever refer people there, I will probably be the person that you talk to help get them integrated into the center. So glad to be here. Nice to meet you all.
Okay.
Okay, so Love Makes a Family. Why did I decide to do this presentation, and why is it important to the trust and estate practice? For many years, there's been an evolution in the definition of the parent-child relationship under the probate code. And a lot of times professionals' knowledge about this presumption of parentage has not kept up with the law. And so what I found when I was practicing was that there was just a lot of need for education on this topic, both with the judges and certainly with practitioners. And I also found that across the boards, whether it's in the drafting phase or the administration phase or the litigation phase, professionals' erroneous assumptions about what natural parentage means can impact families for generations, and I'll talk a little bit about a story to that effect later in the presentation. But it's critically important to really know this topic, because it is our responsibility to identify who the heirs and beneficiaries are when we see the terms child and parent, and to realize that what we think the law is may not actually be what it is, and what we think natural is may not be what natural means under the law. So we want to consider the diversity in family building affects parentage determination. Two main things that have happened in the last 20 years are extraordinary advances in reproductive science that really change the way families originate and children are conceived, and also an extraordinary evolution in the study of gender and in the way families are composed, same-sex families, gender non-binary families, all kinds of different families that are not necessarily the mother, father, husband, wife mold that used to be. And so these families are real, and the law in California is at the cutting edge of acknowledging and recognizing the full legitimacy of all families. And so that's where this topic comes from. So, but it's not only LGBT plus type of issues, it's also blended families, step parents. What is a step parent's rights, and at what point does a step parent become a presumed parent? Foster and adoption families, and sometimes there's a little bit of gray area when there's a family that feels like they've adopted a child but maybe haven't completed all the legal processes, or maybe they can't because there is a biological parent who won't consent. Single parent adoptions and partner-led families, so in families where one couple adopted a child and maybe the second parent in the couple didn't for whatever reason. And likewise, we're going to cover inter vivos and posthumous assisted reproduction, and so where people are saving their genetic material and then a child is conceived after death or born after death with that preserved genetic material. And what does that mean for parentage presumptions and determinations? We're also going to cover donor-involved families. So a lot of families, there's a donor who maybe is a part of the child's life in some form or another, and maybe even called dad or mom or whatever the case may be. And so we're going to cover what the impact is of that type of a relationship where there may be multiple people that the child consider their parent, and how the law treats that. And like I said, we're also addressing LGBT, intersex, and non-binary led families. So my personal stake in this subject, I am the natural but non-biological mother of 3 of those kids, the baby and the twins in the middle there. And that relationship, of course, is very important. They are the children of my 11-year marriage, and they were born within our marriage, my wife and my marriage. And so I have a personal stake on that front. And then also I originally became familiar with this area because before I entered the trust and estates world, I was a child welfare attorney. And so in the child welfare courts, dependency proceedings, parentage disputes play out every day. And so I got really deep into parentage law through that experience as well.
Mine's the little one on the end. Also natural, non-bio.
So parentage determines the outcomes on so many issues within probate practice, but also outside of probate practice. We need to understand parentage law to identify heirs and beneficiaries, avoid and resolve permitted heir contests or omitted heir contests, determining who has administrator priority, and that comes up. Determining family allowance rights, construing instruments, standing rights to notice, all of these things. And then outside probate, of course, it's important in custody and support, dependency law reunification, wrongful death suits, it plays in there. Parentage also plays in citizenship and immigration, although citizenship and immigration, because it's federal and a lot of times dealing with children who may not have been born within the state of California, we're not going to be addressing that today. It is a little bit outside of the California law ambit of today's presentation. But parentage also determines Social Security and survivorship benefit outcomes. Disposition of every trust, of course, and will begins with legal parentage. We need to look at the definitions of an instrument as compared to statute of California law and consider what issue means, what child means, what parent means, and what heir means. And all of those definitions are provided within the probate code. But those definitions, if you look over to the portion of the probate code that they refer to, cross-reference the family code. And that's where I think there's a big disconnect between what's happening in probate and what the law actually is. And we'll talk a bit about that. So, I want to make sure I'm not
Nope, you're good.
Okay.
I will stop you.
All right. Parent-child relationship in probate begins at probate code section 6450, that the relationship of parent-child exists for the purpose of determining intestate succession by or through from a person in the following circumstances. The relationship begins with natural parents, regardless of the marital status of the natural parents, and through adoption. So natural parents is really where we run into the false assumption, because many practitioners assume that natural means biological. So I'm going to defer to Summer for the next couple sections here.
This is California default natural parent-child relationship presumptions. Okay, so test your assumptions, true or false. So this is where you are kind of gathering what you think at this point. When a statute says natural, child, or parent, it means biological. What do you think? What do we got? False. Okay. DNA tests, and I'm not going to tell you, this is we're going to talk about this. DNA tests are admissible to prove heirship.
True.
Okay. A person subject to a court order to pay child support is a parent for heirship purposes. Okay, so we've got some questions there. Good, you're at the right place. A child can have more than 2 natural parents.
Sure.
Okay, we good. And children conceived posthumously by AI or IVF after a biological parent's death may be excluded from the deceased parent's line of succession. Okay, we're right about all this. So,
We need this presentation.
you're in the right place. Let's do this. Okay, so let's talk about California parentage laws and how they are gender neutral. So in 2005, through a trilogy of cases involving my people, the lesbian-led families, the California Supreme Court found that a child could have 2 parents, both of whom were women. So that extended to both of whom were men. And there are sets to that. In 2013, under AB 1403, amendments first recognized the possibility of more than 2 natural parents. So that's correct, you can have more than 2 natural parents. And gender-neutralized rebuttable parentage presumption language. And in 2018, AB 2684 extended the conclusive marital presumption to same-sex parents and gender-neutralized artificial insemination-related genetic testing requirements. So that's kind of the timeline of what we've been dealing with. I think this is.
So within California, there are basically 3 paths to intestate parentage. 1, statutory natural parentage. 2, adoption. 3, equitable adoption, which is limited and only under the common law. We're going to focus today mostly on that statutory natural parentage, but there may be some little weaving in to some adoption scenarios as well. Fundamentally, oh, sorry, we have a little bit of an old slide.
There it is, sorry for that.
No, actually, it is the other slide, it's just that there was a...
Extra? My bad.
Yeah, it's okay, it's okay. So fundamentally, we're repeating it several times because the exclusive means for determining parentage in intestacy proceedings other than parentage by adoption is through section 6453. It is the most important starting point in the probate code for the parentage analysis. And under that analysis, there are many ways that specified under the probate code. What I found in practice was that many practitioners stopped at the explicitly outlined options under the probate code, but they skipped the part that says Family Code 7600 parentage presumption applies and is not rebutted. And Family Code 7600 is huge, and it covers a litany of different ways that a person can be presumed to be a parent. And so it is critical in the parentage analysis that we don't skip that step and don't misunderstand what that 7600 presumption covers.
So we had that question to test your presumptions, I guess, about whether a DNA test could prove heirship. And some of you said you thought it could, and some of you said you thought it couldn't. Well, we're getting to it now. Genetic evidence is seldom relevant to prove or disprove heirship, actually. After a putative parent's death, genetic evidence is only used, or is possible to use, but it's only when it is impossible for a parent to hold the child out as their own.
So it's important to understand what that impossibility
Yes.
presumption looks like.
No, you go.
Okay. It's important to understand what that impossibility presumption looks like. It is somebody who maybe never knew that a child was born of their genetic material, or a person perhaps who died before the birth of the child. That is what impossibility looks like. Under the case law, cases that show that a person was afraid to say something, or their family circumstances made it untenable to disclose their parentage, that's not impossibility, that's untenability, and it's different. So impossibility is the standard to open the door to the use of DNA in probate. Other than that, we're looking at the rest of the 7,600 presumptions, and DNA. DNA, of course, is relevant during a person's lifetime, but after death, it is generally irrelevant.
And there is a case that you look to for that, which is the estate of Breitel, and I know that you really enjoy the facts of that case, so I'm gonna defer to you on that, but that's the case that we look to when we're looking at this section.
Sure. Breitel was a really interesting case, came out 2 years ago, that really kind of turned the progression of the analysis that's been happening in the family courts on its head. And Breitel came out of the probate courts. And it really illustrated the distinction between the underlying policies in the family law arena versus the underlying policies in the probate arena. So this was a family that 2 students at Harvard, whatever
Business school.
they prepared
Not lawyers.
2 students, male and female, conceived a child at Harvard. They were unmarried. The man in the relationship was from a conservative family. I think they were Muslim. I can't recall
They were.
what faith. But it was untenable for him to share that he had conceived a child out of marriage, and after he knew of the child, but after the child was born, he basically wiped his hands clean of it, and the mother, coming from relative means herself, didn't have a significant need to pursue that, and didn't during his lifetime. But while her child was still a youth, I believe around 10 years old, the biological father died in a cycling accident. And after the biological father died, the mother came forward as GAL for her daughter and sought inheritance rights from the biological father. The ultimate outcome of the case was that because she had taken no steps to establish parentage during the father's lifetime, the fact of his biological paternity was irrelevant to the probate analysis, and what the probate court was looking at was the 7611 and also the 6450A standards of whether he had openly held the child out, and of course he had not. And the court also found one of the nuances was that he had in privacy shared his concerns that this child existed, so it was known that he was aware that the child existed, but he hadn't openly held the child out to his community in a non-secretive manner. So ultimately, the child was not considered a legal child of this father, and she was not an heir to his estate. And the underlying policy difference is that in family law, they're looking at the best interests of the child, but in probate, we're looking at what was the decedent's intention, and so the probate court assumes that if a person didn't acknowledge the child to be their own, that they did not want that child included in their heirship line of succession. Yes?
So in that scenario, is it conceivable or possible that the child could then sue their mother for not doing something while father was alive, that then ultimately, like, it seems to me like, but for mother's actions or inactions, child was ultimately not considered an heir. Yeah, harm. Is that the next step, or am I just...
It's an idea.
Okay.
I mean, I think that's a little outside the scope of what we've been studying on this presentation.
Very lawyerly.
Sorry.
So I don't know.
Yep.
It's an interesting thought, though. It's very interesting. Yes.
How does this work if you're looking at inheriting from a sibling? Maybe the sibling didn't know that they had a half-sibling while they were alive, they die. So they say, well, I inherit from you because you didn't have kids, I'm your sibling. How do you figure out the testamentary intent if you don't use biology?
The determination of parentage is looking at the parent-child relationship, and all extended family relationships flow from that analysis. And so whether it's a grandparent who openly acknowledged the child as their grandchild, or a sibling who never had the opportunity, that's not the legal analysis that the statute provides. The statute provides the analysis based on that parent-child connection, and if it meets it, then they are grafted into the lineage of the entire family. And if it does not, then they don't. That's the current state of the law. But the law is ever evolving, and so it's quite possible that the right case would create a new precedent in this area of law.
So a scenario I had in the case years back was dad took off before child was born, never to be seen again. Never held the child out to be his own. Child, many years later, died intestate, and the court ordered us to try to find relatives on dad's side, which we eventually found like third cousins. But this seems to say that third cousin, that whole direction, if dad was never in the child's life, they might not have had any intestate rights.
It depends. So if it was a child born, there's a lot that we're going to get into the different lines of analyses. And so sometimes the biological connection or the connection through marriage or a different 7600 presumption other than openly holding out may apply. And so the entirety of the 7600 analysis needs to be reviewed, but it's possible. It's ultimately, if you follow the 7600 analysis, that's going to lead you to the answer of the situation.
Let's talk about child support orders, okay? And whether they demonstrate parentage. So a court order entered during a parent's lifetime declaring parentage conclusively demonstrates parentage. A parent's failure to support a child or engage in any meaningful parent-child relationship is meaningless to their natural parent status when section 6453B1 applies. But a parent who abandons their child during childhood and fails to provide support may lose their right to inherit through that child. Seems like people get that.
Yeah, that was important in Bertel, and that was a significant factor in why that case turned the way it did. That the mother didn't get a child support order during the child's lifetime.
So that might be something that Doug was pointing to, which is maybe that her inaction in that would cause some damages to the child.
Yeah.
If you're going that route. Family Code Section 7600, definitions and presumptions. Is this still me? I think I stepped over you.
Oh.
So more Family Code Section 7600 definitions. So we're going to talk about 7601, natural parent and parent and child relationship. So natural parent means a non-adoptive parent, excuse me, established under this part where biologically related to the child or not, whether biologically related to the child or not. So that's goes back to the situation that Jonna and I have. This part does not preclude a finding that a child has a parent and child relationship with more than two parents. The parent and child relationship extends equally to every child and to every parent regardless of the marital status of the parents. So it's under 7602. And under 7611, natural parent presumptions. So this is, parentage is presumed when section 7548 conclusive marital presumption or other marriage and attempted marriage presumption applies. Unmarried parent signs a section 7570 voluntary parentage declaration. Marriage or attempted marriage plus either birth certificate by consent or written or ordered support obligation. Section 249.5 applies, and we'll get into that. Orderly departure acknowledgement provisions apply, or 7611D.
So 249.5, we're going to talk about posthumous adoption. And then 7611D, that's the brought the child into their home and openly holding out.
Right. And more parentage presumptions are marriage neutral. So the parent and child relationship extends equally to every child. I think I already read that actually.
Donor conceived children.
I think I went backwards. Donor conceived children. I miss you. I lost my place. Ah, got it. Donor conceived children are presumed children of a consenting, intended, non-biological parent. So I could talk probably a lot about this, just because my child was donor conceived. So both parents should consent in writing, but if they have clear and convincing evidence proves consent, if the parents failed to make a writing. Donor who gives their sperm to, or whatever, to a licensed facility is not a natural parent unless otherwise agreed by signed writing of donor and biological mother. Donor outside facility is not a natural parent if agreed in writing before conception, or clear and convincing evidence shows an oral agreement. That's kind of important too. Donor and carrying woman can confirm donor's parentage by signed writing before conception, and egg donors can prove parentage by satisfactory evidence of intent to be parent. So that's all very important stuff to know, just because there's a lot going on with donor agreements now, and there's a lot of different ways to create a family. Section 7611, which I believe is still me. The presumed parent receives the child into his or her home and openly holds out the child as his or her natural child. I'm so excited that Rachel came in at this point. We had a case together today. So fundamentally, an individual has demonstrated a commitment to the child and the child's welfare, regardless of whether he or she is biologically the parent, is entitled to the elevated status of presumed parenthood. And what evidence rebuts the presumption?
So what we've been talking about with 7600 and 7611 in particular is the presumption of parenthood. But the code provides that in certain circumstances that presumption can be rebutted, but the evolution of the law has really changed by what standards the parentage presumption can be rebutted. So for instance, before 2013, there could only be two parents, and so there was a lot of need to have these disputes where the parentage presumption was rebutted. And so someone who, say, had signed a voluntary declaration of parentage might be in a parentage dispute against the person who had raised the child and the child recognized as their emotional parent. And in that time, the cases where that came up, the person who'd signed the voluntary declaration often won because it was a conclusive, the voluntary declaration was tantamount to an order of parentage. And so those orders of parentage, whether by voluntary declaration or because there was a child support order, would conclusively decide who the second parent was. That was a real problem because on the other side, you had children who had established relationships with the person who'd actually raised them. And that person in the juvenile court context might come in and say, I want to be the wife or the mother, maybe having drug issues or whatever. And then here's this other person who'd responsibly raised the child. And that person could potentially be cut out of the reunification process and the custody option because some third party who hadn't seen the child in 10 years had either signed at birth or had a support order, even though they never paid support. So the legislation in 2013 really fixed that by opening the door to the reality that there could be more than two legal parents. And so now, the 7611 presumptions can be rebuttable, and 7612 is where we look to see what, go ahead. What do you think?
Sorry.
7612 is where we look for the standard to rebut those parentage presumptions. The law has always said that it's rebuttable in the inappropriate actions, and so the 2013 legislation really changed what appropriate action means, and it is now when the rebuttable parentage presumption of one conflicts with the parentage presumption of another, but also when limiting a child to two parents would not be detrimental to the child. So what that is to say is that it is still the presumption that a child has only two parents, but the law creates this flexibility that the courts can say, no, that's not okay here. This kid has two legal parents that are already established and a third parent who has been living as a parent, and the child is connected to them like a parent, and it would be harmful to that child to eliminate that person from parentage, and courts do that now. I haven't seen this happen in the probate context yet, and so you may find a case where somebody already had two legal parents and maybe two biological parents, but a third party is in the mix and had a loving relationship with the child, or maybe even that's the decedent. This analysis is something that would be new to the probate court, but it'd be interesting to see what it would look like when brought into the probate context.
Rachel.
Yeah.
Would this apply to step parents?
I'm sorry?
Would this apply to step parents because the probate code already has a section that applies to step parents? In the guardianship
Yeah.
context or in
That is an open question, because right now the step parent provision, it doesn't have plain language that says that it's the exclusive means for a step parent to establish parentage, but there also haven't been a lot of cases addressing the question, and so there's going to be a Trust and Estates Quarterly article coming out that I wrote while I was with Hartog Bear in Hand, and it addresses this question and kind of goes into maybe this, maybe that analysis, and looks at some of the case law that leans on both sides of that question.
But you can't give legal analysis.
Not today.
Not today.
No, I mean, the crux of it is that there are cases that kind of support both sides, and so I do think it's legitimately an open question. But the policy that we're seeing certainly supports the idea that a step parent could be a presumed parent. And in fact, in the juvenile court, there are cases where step parents were found to be presumed parents. But those cases predate 2013, and those cases didn't evaluate the separate step parent statute, and so that we find that tends to govern in probate law. So I think there are some legitimate open questions, and it's really a ripe question. But there are policy considerations on both sides, in that a lot of step parents are in a situation where they love their stepchildren. Their stepchildren may or may not call them mom or dad, or whatever parent title. And the line between step parent and parent gets confused. And so deciphering when the step parent intended to be regarded as a biological parent and didn't it is a difficult analysis, especially because in step parent situations, there's often the family of origin that was separated. So there's just a lot of, I think that's one of those areas that is ripe, but it comes with a lot of important interests on both sides of the question.
Was it the second question?
My question was actually related to that if the third parent relationship was, say, a same-sex relationship with one of the biological parents at a time when they couldn't legally be married, how do you know what the intention was with respect to that child?
Yeah, and that's where it's developing. It's developing.
Stay tuned.
Yeah. So, but certainly, I think 7611 D should be considered in connection with the step-parent provision as well. So it's important to look at both sides and consider that carefully.
Posthumous conception, which I promised to talk to you all about, 249.5. So, conditions for heirship and beneficiary rights for children conceived posthumously. Child or representative must prove the following by clear and convincing evidence. So that's a higher standard, right? The decedent specified in writing that his or her genetic material shall be used for the posthumous conception of a child. The writing designates a person to control the use of the genetic material. Designee issues notice within 4 months of the death certification that the decedent's genetic material is available. Embryo must be in utero within 2 years of the date of death certification, and we are not dealing with clones yet.
So this is one when we did the true-false that it was inaccurate. So it is true that a person born posthumously could potentially be grafted out of their family line if the 249.5 conditions were not met, and this does happen. And there's a lot of, and you can see how it could happen. A child, someone has cancer, they preserve their material, they don't have an agreement in place. Surviving parent uses that genetic material after the parent is gone. And maybe that was what they always intended, but they didn't do the right documentation. They didn't see a lawyer about it before the death because they were dealing with cancer. So this is an important area to educate clients about, and probably the medical profession as well. I think a lot of donor clinics are the facilities where genetic material is stored do have legal counsel, and so these are being done through those facilities, hopefully. But it's certainly something to be aware of. And this also comes into play with grandparents. In this kind of a scenario where 249.5 wasn't followed, that child may very much be a part of the biological family structure, and the grandparents call them grandchild and consider them grandchildren. But because this wasn't met under a default heirship standard, they don't qualify, or won't necessarily qualify. There are other provisions that you can kind of lean to and make an argument, but it's a challenging argument. So this is one of those issues where planning becomes so very important, and defining terms in a legal document becomes so very important. And to consider this, because most grandparents are not going to come to the planning attorney and explain the nature of the conception of every one of their grandchildren, and I would imagine it's pretty awkward to ask about that. But it's important to introduce this conversation to make sure that any child that may otherwise fall into that category is covered and not left out of the family succession, and you can graft them right back in through the trust and estates documents.
Ambiguous dynasty trust example, determining remote family lineage. Okay. So, it's important to go over California defaults and redefine relevant terms in your instruments if somebody doesn't agree with them. Pay attention to terminology usage in your documents and to address ambiguities with your clients.
So I have a story about this one. We had a case many years ago. It was about a dynasty trust. So we had a family that had about $100 million trust, and it went on for 4 generations. At the initiation of the trust administration, the trust said children and it said issue, and children was redefined, or actually issue was redefined, I think it was children. Children was redefined to exclude adopted children. Issue was not redefined to exclude adopted children. And in the 2nd generation, the patriarch had 2 adopted children. Well, when the trust was originally administered, the 2 adopted children were presumed out because of how the trust had specifically defined children to exclude adopted children, and they wanted the settlor pretty clearly was talking about his biological lineage, and that mattered to him. But throughout the document, when referring to the beneficiaries, it wasn't the term children that was used, it was the term issue. And so what happened was this trust was administered excluding the adopted grandchildren for a term of about 20 years. And then suddenly something came up and those adopted children became alert to the existence of the trust and alert to this issue, and they sued after the biological grandchildren had been receiving benefits and literally millions of dollars in distributions for the last 20 years, relied on that. They bought their homes, they invested, all of it. They were deep in with that wealth. And meanwhile, these adopted children came from the outside and they sued for disgorgement of all of those distributions, and they wanted their shares back from the innocent beneficiaries who had no part of any of it. And they didn't know. They just were receiving the interest that they'd always been given. And so it created millions and millions of dollars of litigation and certainly havoc among the family, all because the estate planning attorney defined children but didn't define issue, and tried to get around the statutory presumptions. So that's,
What?
It was complicated. I think they ultimately settled. There were a number of conflicts of interest came up, so my firm ultimately had to step aside because a conflict of interest arose. But ultimately, I'm pretty sure the family settled and figured it out. But it took a lot to get there, and several years of litigation to get there. So
Exciting. I'm going to jump ahead to equitable adoption, because we're running a little bit behind. Statutory probate code 6454, and I'm sad that Rachel's out of the room for this, allows intestate succession through a step-parent or foster parent when a relationship began during minority and continued throughout the joint lifetimes through clear and convincing evidence that the step-parent would have adopted the person, but for a legal barrier. Doug, you should listen to this too. And common law applies if 6454 doesn't. The common law elements are also right there. So Doug and I and Rachel all had a case together where we had a 6-year-old child who was had a biological father who was not in the picture, would not allow her to be adopted by stepdad, but stepdad and mom told everybody that she had been adopted, right, Doug? They changed the name. I love that Rachel's not here, so I can tell her the facts I want. Changed the name, changed the birth certificate. She told everyone he was her father. She called him dad. She never knew her other dad because he was a deadbeat. Father-daughter dances, Father's Day cards, we had all of it. And so we had a case that we thought rose to the clear and convincing evidence standard. It did eventually settle, but it was very...
The night before trial?
The night before trial.
As most cases.
But it was very interesting to just see that somebody could actually be an impediment to their child being adopted by somebody who clearly wanted to adopt them, and yet it affected their inheritance rights and a whole bunch of money. So.
Summer, if I recall, wasn't the biological dad agreeable with his daughter towards the end?
Oh yeah, once
Yeah.
the father actually passed away, the deadbeat dad came back and was like, yeah, also I'll come testify that I was a deadbeat and that I wouldn't sign anything and that I was a jerk, and that they asked and I was like, nope. So it was an interesting case, and so I just wanted to show you some facts.
yeah, and 6454, that is the provision that kind of stands next to 7611D of the Family Code, and that question of is this exclusive to step parents, or does 7611D also create an option for step parents to qualify as presumptive parents? And so that will remain a ripe issue until someone brings it to a judge. Now, equitable adoption, it's important to note that it's a common law option. It is limited in its scope. A person found to be equitably adopted is not necessarily a presumptive heir within a family line of succession. It's really just they will receive the inheritance rights and stand in the shoes of a legal heir for that parent-child relationship. But it doesn't extend to the it doesn't extend to the grandparent lines and the more remote lines of succession.
We already talked about, does 7611D outdate equitable adoption? I know you have some additional thoughts on that. Did you want to?
Yeah, and I think it goes to the step-parent question that we talked about, is that on one hand, you have this equitable adoption standard that's really quite rigorous, and there's the level of proof required to show that someone tried to adopt and would have adopted but for a legal barrier. Those cases are few and far between, and that legal barrier is a really high burden to hit, and it tends not to happen unless somebody wouldn't consent to an adoption and you actually commenced a process. The other big issue that happens when trying to prove equitable adoption is that if the child reached adulthood, that legal barrier is removed because the biological parent or natural parent's consent is no longer required after the child meets the age of majority. And so a lot of the equitable adoption cases fail because the child reached 18 and there was no adoption. And so that's where, but at the same time, once a person reaches 18, a lot of people, it never occurs to them that maybe I should adopt. For the same reason it doesn't occur to them to prepare an estate plan. They're just not thinking about dying.
And that was the tricky part on our case, is that our client thought she had been adopted and they were lying to her and saying that she had been adopted. I just wanted to know that. So it was just very funny.
Yeah, and so the family's just always been operating like adoption. People just don't think like lawyers all the time. And
Thank
so,
God.
yeah, so the big question, like we talked about earlier, is given the progression of the law, are we now looking at a world where equitable adoption is kind of an outdated standard? And does 7611D, now that we can have more than 2 legal parents, maybe 7611D outdates the need for an equitable adoption analysis. So that is not something that's been decided in any court, but it is certainly a question that comes to light when looking at all these analyses. So I want to talk, before we go into the true false, I want to talk about some practical tips. When drafting an instrument, it's really, like I talked about this dynasty trust example, it's really important to be clear about exclusion or inclusion of biological and non-biological lineal descendants. And it's also important to look at the language of the instrument and see, is it up to date with the terms that we talked about at the beginning of this presentation, or is it using outdated terminology? So for instance, red flag language in an old trust would be the use of the term lineal descendant, or as defined in this instrument, as defined in this instrument, because that kind of language is going to give rise to the question, did this settlor intend to exclude the statutory language, or did this settlor was it an inadvertent drafting error? And so it's really important because a lot of times when a person says, as defined in this instrument, they go on to talk about lineal descendants, not the terms that are actually defined in the statutes. And so it's just really important to look at those types of terms and make sure that if the settlor wants to create a definition different from what the statutes say, they need to be really, really clear that that's their intention and they are substituting their own definitions. But if they don't, then avoid that, it's probably good to avoid that kind of lineal descendant or as defined in this instrument kind of language, and really be clear that you are adopting the statutory language of issue, natural child, parent, and don't substitute lineal descendant for issue unless you really need to do that. So. The other thing, of course, as in the Dynasty Trust example, is that if you do have a situation where your client wants to keep the bloodline blood, be sure that you're using the right language throughout that document, because the courts a lot of times want to lean towards the statutory presumptions, and there's a lot of good policy behind not excluding non-biological kids from the line of succession, and so the courts will take, if there is a way for them to keep within the statutory analysis, they're probably going to do that a lot of the time. So just be really cautious about this terminology and then the way the terms are used within the instruments. All right. The true false.
I think we've gone over it, but
Oh,
I think we've kind of hit on everything, but
Yeah,
we want to circle back.
so these are the answer keys, and yeah, we did kind of reference throughout the presentation. I think the original consensus was 3 incorrect and 2 correct. So hopefully this has been helpful to get a maybe understanding of the current state of the law. And yeah, so at this last slide, this is just a quick cheat sheet to the analysis that starts at 6453 of the probate code, and that'll help you when these kinds of situations come through your office to go through this statutory analysis. Do you have any questions?
Okay. Well, then we are going to switch gears here, and we're going to move to our next PowerPoint, which is on transgender inclusivity.
I actually have a question. So
Sure.
the slides that you just showed, is that intended to be part of the material that we're supposed to be downloading?
You should have received those.
Okay, because I downloaded, maybe I'll ask you later, the material I downloaded only included, I think, this
Yeah.
presentation.
Yeah, me too.
Well, that is,
Oh, really?
that is a mistake.
But
so-
it would be great to have those.
Yeah, we want
Yeah.
those other.
Yeah, I sent, I'll check in with the CCBA and make sure that you guys all get an email.
Absolutely.
That has the presentation.
Okay, so I want to start by introducing myself again. My name is Summer Selleck, and I want to explain that I go by the pronouns she, her, but I also go by the pronouns they, them. This is Jess, and I'll let Jess introduce himself.
Hi, I'm Jess, continuing to be, and I use the pronouns he, him.
And yeah, we will talk more about that, and that's why we started on that. So I want to start the process with this gingerbread person that you received, if we could turn to that. There are a lot of terms on this. Let me get you. Oh, you can grab that. Thank you. So there's a lot of terms on here, and we want to go through them because it's a little bit confusing and also a little bit of a lot. So this is a gingerbread person, not a gingerbread man or a gingerbread woman, but it's a gingerbread person. And if you start at the top of this gingerbread person, we start with sex assignment. And it's important to look, I'll just go here. We'll slip. Okay. So sex assignment. So we've got female and male. Sex assignment is obviously when a baby comes out and the doctor yells, "It's a boy," or "It's a girl." But it's important to also note that there is a third sex assignment on this, intersex or other. And traditionally, usually back in the day at least, doctors tended to shun away from allowing intersex children to just be who they were. Instead, they forced them into one of the genders, either male or female, and one of the sexes, male or female, and now there's a turn away from that, and an allowance where children are able to be who they want to be and decide, if they choose to decide at a later date when they have a chance to do so. So we did go ahead and leave that section there because it's important to note that there is more than just 2 sex assignments. Gender identity. Do you want to talk about that?
Sure.
Okay.
So I think the main thing to take away from this part here is the difference between sex and gender. A lot of times, socially, culturally, historically, those have been conflated into one thing. So when the baby comes out, or a lot of times nowadays, before the baby even comes out,
8 weeks or 16 weeks?
yes, we are making a declaration about that person, that baby's gender, when we're actually making a declaration about that baby's sex based on their external sex characteristics, so what their body parts look like. So gender identity is something different from that, something that is not always visible by looking at someone. So gender identity, as you can see here, is an internal, deeply held sense of who you are. It's something all of us have. Some of us have that be a pretty given thing that's not something that we have to consider a lot throughout your life. Other people, like some of us, have that's something that has produced a lot of conflict and something that you have to kind of work through and figure out throughout your life. So, but like all of these things, and as you can see on the genderbread person, those things are a spectrum.
And then gender expression is identity that is invisible to others. So as you see on the gingerbread person, the expression is what is on the outside. So it's what you project to the world around you. So if you see somebody in a dress, you're going to say, I see Laura in a dress, I'm probably going to say, she looks pretty feminine. If I see Doug Hausman in a tight little suit, I'm going to say, he looks pretty masculine. So that's the difference between gender identity and gender expression. Okay? Genetic sex, that comes down to, do you want to do that one?
Sure.
This is another gingerbread person. So we created our own. The one that you have in front of you is adapted by JFK University. And I like it just because I just think it has some additional things that make it easier for us to understand. But this one is also totally adequate. And it expresses the spectrum. I know when we say the word spectrum as lawyers, we like to think something as linear, but you have to try and, I think, remember that the spectrum is not linear. It's all over the place. It can be up here, down here, over here, to the side. So just try and remember that. So here's another gingerbread person. You've got a copy of that in your slides. We'll come back. Okay. So genetic sex.
So genetic sex or chromosomal sex is determined by the actual chromosomes within someone's body. So that's typically XX or XY, but there are, just like Summer said, there are variations and spectrums within that too. It's not always fits into those boxes neatly, and typically not nearly as common as we tend to assume that it does.
And also another thing about genetic sex, you can't change your genetics. It's always going to be XX if you were born. Yeah, it is what it is, as they say. Phenotypic sex, I hope I'm saying that right. That is the manifestation of sex determined by endocrine influences, such as development of breasts and genital organs. These things can be changed. So unlike genetic sex, you can have a reassignment surgery, you can take hormones, you can take testosterone, you can do all of those things. You can alter this part of your gingerbread person. Sexual attraction, I'll need to put that to you.
Okay. So sexual attraction is something that probably doesn't need a lot of explanation.
But I still like to talk about it.
Let's talk about it. So who you are attracted as a person, what kind of person you are attracted with. So again, this is different from all of these things. Like I said at the beginning, we do tend to kind of conflate all of these things into one. So we make assumptions where if you see someone, I'll keep using you as an example. If
Laura
you see
loves it.
someone who is wearing a dress and you assume that person is feminine, assume that person identifies as a woman, assume that woman is attracted to men, we tend to do all of those things in a split second. So part of what we want to talk about today is how we sort of unpack those assumptions that we make and slow down in how we do those things and sort of examine why we make those assumptions. So sexual attraction is another piece of that. So someone might, in terms of their attraction, identify as straight, gay, lesbian, bisexual, many different terms.
Yes. Romantic attraction describes a person's romantic attraction to another person. So even though Laura might be sexually attracted to men, she might also have romantic attraction to women because, you know, they're nicer sometimes. Because why not? Because why not? You know, that's where it is at. So what Jess and I are going to do is be super vulnerable for you, and we're going to go through and we're going to actually demonstrate what we are on the gingerbread person. And then we're going to see if you want to partner with people around you and do it for yourselves. So we'll go first. I lost my pen again. Well, don't steal my stuff. So I'll go first. So sexual assignment at birth, the doctor said it's a girl. So I was a female at birth. My gender identity, I identify as gender non-conforming. So I would be on the otherness spectrum. And that means that sometimes I feel really girly and sometimes I feel masculine, and so it's really how I feel the day of. My gender expression, I think probably because I'm wearing a suit right now and a tie, that y'all would probably say that I am more on the masculine side, but you know, sometimes I don't know, I wear sweatpants and I feel girly, I don't know. My genetic sex, I was born with the XX chromosomes. My phenotypic sex, I have taken testosterone, and I have, and this is all very, this is something that you don't ask people. It's not anyone's business, but I have had top surgery, so I am definitely other, I think, is more closely related to what I would be at this point. Sexually attracted to, I'm married to a woman, so I would say women. Although I do think that Doug Houseman is very attractive.
I think we got a vote on that one.
And romantically attracted, once again, I'm married to a woman, but once again, Doug Houseman is really, really, if he ever doesn't want to be married to his wife, then I would really do it. So, and then Justin.
All right, so for me, in terms of sex assigned at birth, I also was assigned female at birth. So that's how I was raised as a child and a young person. In terms of gender identity, I do identify on the masculine or man side of the spectrum, depending on how you're phrasing that. Gender expression, I do typically present and express myself in a more masculine way. This is, I don't usually wear a jacket like this. I dressed up a little bit for you all, but usually I do express myself on the more masculine end of that spectrum. Genetic sex, you know, I actually don't know for sure. My assumption is XX, but
It is probably.
never been tested.
More likely.
Phenotypic sex, similar to Summer, that has changed throughout my life. I have been taking testosterone for a while, so in terms, if you were to measure that, it probably falls somewhere in the middle. For both sexually attracted and romantically attracted to, I identify as bisexual or pansexual, meaning that I find many different types of people attractive. Doug, sir, I just met you. You seem,
I mean, you're really a hot topic in this room.
Flattered.
Yeah, so I am married.
We're all married though.
Sure. I'm married to someone who also identifies as a man, so that is someone that I find sexually and romantically attractive, but I've also experienced that with people who identify as women also.
So what we like to do is allow you, and you can do it in partners or pairs, or you can do it on your own, but it's, I think, important to just take a moment and take a look at this and see where you fall on it, because although you present as a man and you are masculine and all of those good things, and you know that you were born as a man and everything seems like you check all the boxes, sometimes when you look at this, you think, oh, well, I do sometimes feel a little bit, more other, or what have you. And
can I add one note?
yes,
One other thing to consider in all of this is the difference between, and I think we know this later, so maybe this come up again, but the difference between sexual attraction and romantic attraction and sexual or romantic behavior. A lot of times there are people who, and this might come up with people that you work with or clients that you represent, people who sort of present to the world as one way, but behaviorally or internally are experiencing something different. So there's a category that in terms of like public health and all of that, a demographic of people considered MSM. Has anyone ever heard that? So it stands for men who sleep with men or men who have sex with men. That was created out of a recognition. It was during the height of the AIDS crisis and following, when there were all these efforts being made to try and combat AIDS, and those efforts were being targeted towards gay men. But it pretty soon became clear that there were also a lot of men who did not identify as gay, who presented to the world, perhaps had female partners, married families, who in every other way would identify as straight men, but were actually behaviorally sleeping with other men. So when you're thinking about these things, you don't have to disclose all this to people around you if you don't want, but that's something to think about and examine in yourself, the difference between how the choices you make versus how you identify versus what goes on in your mind and in your body, those sorts of things.
we're not collecting them and you don't have to share them, so. So take about 5 minutes, just I hope you feel good. Okay, so we're gonna go back and talk about what it is to be transgender.
All right.
Just take it away.
All right, got it. So what it means to be transgender.
And it means a lot of different things for a
It
lot of
does.
different people.
It does, and that's an important thing to remember, that term is used by different people in different ways, and folks have different relationships to that word. But very broadly and generally speaking, the term transgender refers to someone whose gender identity does not correspond with the gender that they were assigned at birth. Now, that doesn't necessarily mean that they identify as the opposite gender that they were assigned at birth. It just means that they don't identify with what they were given at that point. That's kind of, I think, the most broad way. There's a lot of different ways that transgender people sort of recognize that. That can be through making, and some people do none of these things, but some of those things can be changing the way you present yourself to the world. When we talked about gender expression, that's what we're talking about. The way you dress, the way you do your hair, any of those sorts of things. It could involve legal procedures, which is where you find people come in. That can be legally changing your name, your gender markers, your identity documents. And for some people, and this is very dependent on where people are in the world and the access that they have to these sorts of things, but that could include also medical interventions such as hormone replacement therapy, different surgical procedures. There's a lot of different things that are options to people, again, depending on where they are and if they're in a place that they have access to something like that. So transgender is also an umbrella term. There are other terms that fall within that, and we'll get into a little bit deeper into what some of these terms mean. So the kind of main distinction here is the difference between binary and non-binary transgender people. So binary transgender people is someone like myself. I would consider myself a binary transgender person, which means that I was assigned female at birth. That was the identity that was given to me and that I sort of thought that I had to accept for a long time. But now I do identify as the opposite of that. But like I said, not everybody falls into that category, and those would be considered a transgender person who is kind of in a non-binary category, which means they don't necessarily identify with either the sex that they were assigned at birth or the sex or gender that is opposite of that.
Like I would consider myself gender non-binary, which is what gender non-conforming, gender non-binary. So I would be underneath the other little umbrella. Yet both would be considered transgender. So just to put it all in perspective there. I think we already talked about these things. Transition. So one thing that always comes up and people have some confusion with it is pronouns. And so we want to try and give you a way to sort of understand how to deal with people's pronouns and kind ways to figure out how to ask people about their pronouns. So when we started this conversation, we just started out by saying, these are my pronouns. Jess here has a name tag on that says he, him. I believe that organizations, I know that quite a few organizations have started putting on name tags. I know that we don't in Contra, but quite a few organizations are going to start putting them on name tags. You'll see them in signature lines. That is the future. It's just going to become the way it is from here on out, because she and him, it's just not that simple anymore. And so one way that I think is a good way to start a conversation is just say, hi, my name's Summer. I go by she or her or they or them. What are your pronouns? What's your name? What are your pronouns? You can also make it simple, like I said, by putting it in your signature line of your emails. You can say Summer Selleck, pronouns, she, her, they, them. Those are ways to do it. Do you have any other suggestions?
Yeah, and I think it's something that might feel awkward at first, but gets much easier over time. It's something I do many, many times a day with where I work, and now it's just a very normal part of my conversation, and it feels weird now when I'm in different settings and meetings where we don't all go around and introduce ourselves by our names and pronouns. So it can become a very normalized thing that might seem, if you are someone who uses pronouns who that correspond to what you've always used throughout your life, or that correspond to the natural assumptions people make about you, might feel like a burden or even a strange thing or something that feels uncomfortable, but it goes a long way to making other people who don't fall into that same category as you feel comfortable and safe in sharing space with you.
If I can jump in with a little story here. Wells Fargo really welcomes us to use our pronouns and our signature lines. Everything is very conventional, of course, with a company our size, but we are welcome to put she, her, hers, or whatever pronouns they them, theirs, thank you, whatever the case may be. And so I came out of the 90s, and I'm still a little, even though I'm a lesbian, I still have, it's new. Some of the changes are new to me, and so I was kind of like, and I kind of wrestled with it for a while. Am I going to do it? Am I not? And I ultimately decided to do it because I just felt like, if there's a non-binary family with a non-binary child, or a non-binary anybody, whatever the case may be, I want to show that I'm an ally, and so I chose to do it. But what I found really interesting was that it actually already has opened up new relationships and new depth with some of my colleagues, because even within the bank, one of my colleagues who's a financial advisor has a non-binary child, and so he opened up to me about all the things that his family is going through that. And also some of our banking clients have one of our banking clients has a transgender son, and so it's opened up a lot of questions and opportunity for discussion there, and it does nothing but open up new opportunities, really.
Yeah, I've had no negative feedback from it. I've only had positive feedback from having it on the signature line, so. Yes.
So I actually have a question. As you're raising kids and trying to teach your kids how to approach this the right way, especially for me where I'm still learning the terminology. Say you're at the grocery store or somewhere and you're interacting with someone, and you don't want to assume what they go by, and you're with your kid and you're like, give so-and-so, pay for this, and you would normally say, oh, just assume, give her the money, or
them.
Okay, give them.
And you actually did it, I don't even know if you noticed that you did it just as you were speaking. You were
Probably.
saying, you don't want to assume,
Yeah.
you said you don't want to assume, you might say, give them, you did it without, you used they as a singular pronoun just now as you were talking, as you were asking the question.
Okay.
So we do that all the time without even realizing.
And the more you do it, even when I started, I was like, they and them seems so weird. I don't like this, but the more I do it, I'm like, this feels exactly right.
Uh-huh.
And so it's just fitting
Just
it in.
practice, yeah.
Really? Yes.
Okay.
Yes.
A similar question, a group of my friends and I have been trying to figure this out, so we would like your help.
Yeah.
I need a non-gendered term of respect for somebody you don't know. You don't say sir or ma'am because you don't want to misgender somebody, but leaving it off entirely feels rude. What do you say?
I think there's a lot of ways to convey respect that don't require those terms at all. I think that we haven't, just as a language, I don't think found a term equivalent to sir and ma'am that is non-binary, and I think that's unfortunate, and it's probably something that will change. But as it stands now, I don't think that, and especially, and then I think it's also a generational thing. I'd say younger generations that I don't hear sir and ma'am as much, and people in like kind of my age cohort. So I think that there are ways that you can convey respect and even deference in the way you interact with that person, and kind of like,
Without mix.
well, that, yeah, if you're using Mr. or Mrs., but for like
But if
sir
you're
or
like,
ma'am.
excuse me, blank, did
Excuse
you
me,
drop
mix.
this? Or excuse me, blank, you on my.
Excuse me, mix, MX would be, so sir or ma'am, I don't have anything, but MX is for like Mr. or Mrs., but it's neutral.
Okay.
MX would be the deal, I would say. I'll draw this one out. Okay, so getting into what's going on now in the court system, because we are, so Title VII, sex discrimination. If you talk about Title VII, it discusses sex discrimination and involves treating somebody unfavorably because of that person's sex. There's a baby. Discrimination against an individual because of gender identity, including transgender status, or because of sexual orientation is discrimination because of sex in violation of Title VII. So this is just some background. There is actually a case in front of the Supreme Court now. It was heard on October 4th, 2019, and it's not been decided yet. But under Title VII of the Civil Rights Act, it makes it illegal for employers to discriminate because of, among other factors, a person's sex. But the lower federal courts are divided on whether that language also covers sexual orientation and gender. The cool argument that the civil rights advocates are stating is that one simply cannot consider an individual's sexual orientation and gender without first considering their sex. So it's awesome. I think it's just a great argument. So in this case, you can't consider a gay man is only a gay man if he's attracted to other men. So that's the basis of it. The case is RG and GR Harris Funeral Homes, Inc. versus Equal Employment Opportunity Commission. So basically what happened, what's going on in this case is Amy Stevens was fired from her job at a Michigan funeral home 2 weeks after she told her boss that she was transgender. The company said she failed to follow the dress code. I've had situations like this where when I was teaching, I was told that I needed to dress more feminine or I was going to lose my job. So I've had this same situation happen, so I take this really pretty seriously. So the situation is that basically they're arguing that the funeral home would have treated a woman who wanted to dress or present as a man with grieving family members and clients of the funeral home exactly the same way that Stevens was treated. And that's obviously one side of it. If she had been, the argument is that if she had been assigned female rather than male sex at birth, she would not have been fired for living openly as a woman. So once again, it comes down to, the argument is it comes down to her sex. And so we're gonna wait and hear what happens. Hopefully something good will happen. But right now, just is gonna go over what laws are protecting job discrimination for transgender people in the country and how important this case is, because it really is going to decide whether or not jobs are protected for people who identify as trans. Yes.
So currently there are 21 states that provide protections against discrimination on the basis of sexual orientation or gender identity. There is a few more, 7 more that do provide that, but it's only for public sector employees. So that means that for the majority of the country, for the majority of transgender people who live in other states, they have no protections currently against discrimination on the basis of their sexual orientation or gender identity. So that is a really big issue. The case that Summer just described, if depending on how that ruling comes out, yeah, that could provide nationwide protection for people on the basis of gender identity or sexual orientation. So
It'd be huge.
yeah, that would be very positive and exciting. All right, so the California Gender Recognition Act of 2017. This
This is important for everybody. I was just
No,
gonna say,
go
this
ahead.
is important for the probate lawyers in here. I think just because it talks about name changes and things like that in the probate process, so we'll let just.
Yeah, and you all, I'm sure, understand more of the legal side of it, of how this works. So basically, this act made it a lot easier for transgender or gender non-conforming or non-binary people to change their legal identity documents to reflect their gender identity. So now there's an option for there to be a non-binary option. So you can change if your identity documents say male or female and you would like to reflect that to have like an X on your driver's license. That is an option now. And
It's a huge thing, and it's, California, I think, is one of only.
yeah.
Yeah.
And thankfully that's changing and other states are
Yeah,
adding that all the time.
yeah. And so changes by the date, so this goes over how the changes rolled out.
Yeah, so do you want to talk about this specifically or just kind of overview it?
Overview it, it's fine.
Okay. So like Summer said, this kind of rolled out in different phases of how these changes went into effect and how people can utilize those things when they're changing their name or their gender. And I'm not going to read through all of it. I think you'll have these slides. But just a couple of sort of additional things that I wanted to note related to this. One of the big changes is that in California, changing your birth certificate no longer requires having a physician's declaration, or you used to have a letter from a doctor sort of giving you permission to change your birth certificate. And as you can imagine, or maybe, for me, I find that as a transgender person, I find that incredibly patronizing and demeaning, that I have had to go through so many steps of getting so many people's permission to live my life. So that's really exciting. One thing to note, this doesn't apply to certain things like Social Security documents. So in California, you do still need a physician's letter in order to change your name or your gender identity on a Social Security card. So that's something to keep in mind, yeah.
I have a question. For gender change, and this will come up in the probate court occasionally in connection with a name change request, are there any limits or requirements for gender changes for a minor?
For a minor?
Where, for example, a parent presumably is very involved in the decision. The minor may be in high school, they could be in grammar school. Are there any age requirements, consultation requirements?
No consultation requirements, the parent has to sign off still if they're under the age of 18, but
Both parents or just one?
I think you just need one at this point.
But one thing that is interesting, when it comes to formal documents, that's the case. But when, my sister's a teacher, this is not a legal issue, but she's a teacher and
Oh, yeah, this is cool. This
she
is cool.
teaches in the Central Valley where it's not a
Supportive.
a gender inclusive kind of area. And so she has a number of non-binary or trans kids in her choir because she's a music teacher, she teaches in the arts. And so some of her children have requested to dress in the choir uniforms matching their gender expression. And she wants to support them, so she went to her administration and ultimately found that she did not need parental consent to allow her students to order the choir uniforms in accordance with their gender expression. So even in a place like that, that is there, and the children are being supported. hopefully within most of the school systems, regardless of what the family situation might be at home.
Yeah, I see a trend where even if you're under the age, I see a trend where at a certain point, I don't know what age that would be, where you can just do a declaration and say, you know, I'm 13, I am gender non-conforming, I want to change my name. I just see it starting to happen. It's not here yet, but I believe that we're moving towards that. So, that's my take on it.
A couple other things to note on this. If one thing just about, this is something that I do a lot in my role at the Rainbow Center, is working with people who are changing their name legally or their gender identity. And I don't know if many of you are familiar with what that process is like, but the most common one is working with people in their name. That's usually, if they're going to do the other things, they start with changing their name. That process usually takes about 6 weeks. When you first do it, you fill out all the paperwork, file the paperwork at the courthouse, and this has changed. It used to be, and this is still the case in other states, that there's a 6-week appeal period, so nothing really happens during that time. If you're changing your name, it used to be that when you were changing your name, including for the purposes of conforming with your gender identity, you had to post something in a local newspaper for 6 weeks saying what you were doing and giving people the opportunity to appeal it. Thankfully, that's no longer the case. That is the case in other states, so if you have friends in other states, have them talk to the representatives about that.
Yeah.
Because that's very dangerous and can be very harmful to
Life-threatening.
people. Yeah, so thankfully that's not the case anymore. One resource for this, if you're looking for additional support in the steps that are required for all of these different changes, the National Center for Transgender Equality has a portion of their website called the ID Document Center, and it breaks down by every state what the requirements are for changing all of these documents. So that's a really good kind of quick guide through what you have to do, especially if you're looking at people who were born in other states. Like, for example, there are 3 states who don't allow you to change your birth certificate under any circumstances, even with the court order. Those are Ohio, which unfortunately is where I was born, Kansas, and Tennessee. So folks in those states have no options to change these documents, which means their identity documents will ever be not in alignment.
Maybe not forever.
Hopefully not. There's an ACLU case in Ohio about this that I'm
Watching closely. Good. So, 5 things you should know about trans people. I'm gonna let y'all read that on your own. There are just some things in here that are just for you to take a look at, but you're kind of running out of time, so we're gonna keep trekking along. Cisgender. You might be hearing this word a lot more lately, and so I wanted to let Jess go over what cisgender means and talk about it.
So cisgender is a term that is sort of the other side of the term transgender. So someone who is cisgender means that you're a person who identifies your gender identity aligns with the sex that you were assigned at birth. And those terms cis and trans come from have Latin roots. Cis refers to being the idea of being on the same side, trans meaning to cross that in some way. So that's where the origins of those words. So when you hear words about cisgender or transgender, that's referring to someone's gender identity in relation to their sex assigned at birth.
Heteronormativity.
Sure.
All right. So, this is a hard word to say because there's so many letters in it. Heteronormativity.
Nailed it.
Ah, I did. Whew. So, the assumption in individual institution, in individuals
Now all the words
or
are
in institutions that everyone is heterosexual and cisgender. So an example of this would be a news article that says that something about pregnant women. Well, not all people who are pregnant are women. Some pregnant people can be trans. And so you have to sort of take a step back on everything you see and hear and read these days, because sometimes a group that the people are trying to speak to, you're not including everybody. You're just including a group of people and you're leaving out maybe a small subsection of people. that could also be a part of who we're trying to talk to. So you just have to sort of retrain your mind a little bit. And so, do you have an example too?
Yeah, but this is
Oh,
something we're going to talk about later about
Yeah.
another example of that comes up a lot is on forms, documentation, anything that
Yeah.
lists out like contact information and they have a section for husband, a section for wife, a section for mother, a section for father. Those sorts of forms are very limiting if you don't fall, like all three of us, into those categories perfectly. So adapting forms, and we're going to talk more about that as a best practice, but that's an example of heteronormativity, that making those assumptions on an institutional level where just interacting with the world in really basic ways, assumptions are made about how families are structured that are very limiting and often not true.
It's funny how this has progressed in California. My 7-year-old twins, according to their birth certificate, I'm their father.
I'm Merritt's father.
Yeah, and so obviously I'm a cisgender woman, so, but according to their birth certificate, I'm their father, which is fine.
Fun fact. Fun at cocktail parties.
But my other daughter, the 2-year-old River, I'm parent, I think I'm parent number 2 or something
Yeah.
like that. So the forms have changed just within the course of my own,
The family law
Family
forms have also
development.
changed, and that's made it more inclusive, but
yeah.
things can still change. We've already talked about gender non-binary. Here's a great little picture of hi, my pronouns are, and so this is one of the things we already talked about, which is asking about pronouns. Right? Microaggressions. So I don't know, has anybody heard this term before? Okay, so we're gonna go over what this means. Jess?
Yeah, and this can, just something to note, this can apply to a lot of different situations, not just about gender identity or sexual orientation. This can be about race, ethnicity, ability, all sorts of different things. But microaggressions are just very common, everyday insults or slights. They can be, I think microaggressions are often unintentional, not always, but are a lot of times unintentional, that convey messages like heteronormativity, that convey some sort of difference or othering, exclusion, in small, subtle ways, but if you are someone who is on the receiving end of that, it's sort of like a death by 1,000 paper cuts kind of situation. So again, recognizing the difference between intent and impact. A lot of times we say things that are harmful or hurtful to someone that we think are well-meaning, and maybe we're even a little put off a little bit that person took offense to what we said. But like I said, if you are on the receiving end of that, that can happen in many different ways, and often many times in a single day or interaction. Yeah, so if something like that is pointed out to you, or you become aware that you might have even unintentionally said something or done something that was offensive or othering or exclusionary to another person, a good way to respond to that is by doing your best. I mean, it's natural to feel like self-protective or defensive, but doing your best to kind of resist that impulse and see it as a moment of learning, a moment to kind of expand your understanding of what it means to be respectful and kind to another human being. You don't need to over-apologize. If that's, some people go into that category. Just apologize and adjust your behavior or your language going forward.
Cool. Best practices. Mind your pronouns. So it's really important if somebody like Jess or I have informed you that we want to go by a certain pronoun, it's important not to misgender them. So, and I know that mistakes happen, and so that's okay, but if you make a mistake, you should politely correct yourself. Don't overcorrect yourself, because that's also awkward. Yeah.
Oh, sorry.
No, go
I was
ahead.
going to add a couple more to go.
It's important to respect somebody's identity, so if there's been a name change, it's also important to use their requested name, and don't use any name that they have no longer go by. It's called dead naming. Be appropriate and rein in your curiosity. So we've shared some really intimate things with you today. but you're not supposed to ask what's happening underneath somebody's clothes, so just don't do that, please. And we like to ask you to be mindful of gender inclusivity. Some of the things that naturally happen is, when you go into a room, you say, hey guys, or little things like that. And so just try and maybe have some alternatives. I'm working with hey y'all. And I know I'm not from the South, but I'm working on it. So just little things like that. And you had some?
Yeah, and I think the biggest thing is just not making assumptions, and I recognize that that's really hard to do. Our brains are wired to categorize things. From the time we're very little, we start learning like, this is a cat, this is a dog, and we build upon that. So that's a very natural thing. So I don't want to, it's not necessary to feel like shame or anything about that. That's how we are wired. But so what we're asking now is to just examine some of those assumptions that we make and do our best to unpack those things, and maybe find when those things are not necessary to do in that moment. A lot of the assumptions that we make when we see someone or when we interact with them are completely unnecessary to those interactions, but we just do it naturally. So practicing that sort of art of not making those sorts of assumptions. Another one is when people use words or terms that you don't understand or you're not familiar with. If they say, I identify in this way in terms of their sexual orientation or their gender identity, there's many different words for that, and a lot of times it can feel overwhelming, like you have to know and understand all of these words if you're going to be respectful to people, but that's not necessary. That's partially because of what we said, those words can mean different things to different people. So rather than feeling this pressure that I have to be an expert on all of these terms and all of these identities in order to be just like a basic level of respect, if someone uses a term that you're not familiar with or you don't understand, or a client uses something like that, just ask really simple questions like, hey, what does that mean to you? Or what does that look like to you in your family or in your life or your identity?
It's okay to
Give
ask.
them the chance.
Yeah.
And just leave it at that.
Yeah.
Let them tell you.
One thing that I think is interesting in trust and estates practice, or what we do with trust and estates administrations, is that we're always trying to figure out, the members of the family and develop what's the family tree. And in those conversations, a lot of times there is a trans person in the family. And a lot of times the older generations, they're not accustomed to the new pronouns or to just they are stumbling too, though they care and though they want to be respectful of their family member. And so it's kind of an opportunity too for us to ask the question of our clients, how does your child prefer to be addressed? Or those types of questions, and that conversation and that question also tells the client, it's okay. You don't need to feel like you have some weird thing going on in your family. This is normal. This is a part of the fabric of family life, and we're good. We're all good. So I think a lot of times we will have those opportunities. I have those opportunities all the time, because families are big and families are diverse.
And complex.
Yes.
Some general tips when talking or writing about your clients: use language that your clients identify with. So once again, if they tell you that they want to go by a certain pronoun, use that pronoun. If they tell you they want to go by a certain name, use that name. If for some reason you genuinely cannot use the appropriate name, talk to your client about that. That's like in pleadings. So if they haven't legally changed their name, I get this sometimes, you can use their legal name and say also known as or herein Jamie, and then continue to use Jamie. So there are ways to do it where you respect the client. Focus on what's truly relevant in the case. If it's not the medical history, then you don't need to know about it. Share the information with your client's gender, about your client's gender with the court. What I'm saying is, if it's important in court to school the court about your client's gender, then do so. So if the judge keeps calling your client she and your client is he, then you need to keep making it clear that he is here. He is present, That doesn't just happen with the judge, that happens a lot with opposing counsel and with opposing parties, especially in probate court, guardianships, because they like to make points. But you have to stand firm for your client, especially when you've got a transgender client. Do you have anything to add to that?
Nope.
And some office ideas, and we already talked about this. If appropriate, you can have materials showcasing your diverse orientations and gender identities. In the law, you can add pronouns to your signature line, and you should always try and make your intake forms gender neutral instead of husband, wife, what have you, partner 1, partner 2, children, male, female, gender non-binary. There are ways to sort of make everything a little bit more inclusive. So that's all we have. We've got about 5 minutes for questions. I'm sorry I ran so long. Is there anything that you want to ask? Or, I know it was a lot of information in 2 hours. No? All right, well, thank you for being a wonderful audience.